I'm now going to recognize myself for 5 minutes. Among the specific requirements in the rule, the required disclosures for greenhouse gas emissions data stand out as especially burdensome. These reporting requirements do not track with what is currently tracked by companies and when that information can be reliably reported. The exemption for smaller reporting companies, SRCs, is far too narrow, and this rule will impact many smaller and medium-sized manufacturers, which make up the substantial share of businesses, certainly in my 5th district. And as you know, even with a limited safe harbor in place, the SEC acknowledges that the climate rule will expose companies to increased litigation risk. I'm concerned that the risk will prevent companies from going or remaining public. Mr. Stebbins, would you explain why climate rules' limited safe harbor is not enough to protect companies against increased litigation risks?
Thank you. The safe harbor only covers certain select disclosures, and it doesn't cover historical facts. And those disclosures are primarily going to be comprised of historical facts. And a leading law firm recently wrote a memo about the adopting release, and they concluded, or they advised, that you should not give too much credence to that safe harbor because of the fact that, because it's typically going to be based on used by historical facts. That's going to be your disclosure. So they advised, don't give it too much credence, and I agree with that advice. I think that's sound.
Very good. Proponents of the final rule often argue that climate-related disclosures are necessary in response to the demands of investors. However, I'm concerned that the SEC has finalized the rule not to the benefit of investors, but instead to placate activists who consider climate-related objectives important. Rather than focusing on the financial interests of the shareholders, this idea of stakeholder capitalism that some companies have embraced comes off as more of a PR stunt to evade the actual accountability. Shareholder rights are well defined, but if a company has the obligation to a nebulous group of stakeholders, it's ultimately not accountable to anyone. Mr. Rossman, would you explain why these activists may be better understood as stakeholders and not as investors?
So when people talk about stakeholders, as you mentioned, it's not just stockholders. It can be your customers, it can be your employees, it can be the community, it can be government. It's not just the people who own your company. And one of the concerns that some of the dissenting commissioners had about this was that these rules may be crafted more to satisfy stakeholders than the Main Street investor that historically the SEC thought.
Very good. Chairman Gensler often hides kind of behind this argument that the SEC, many rulemakings are authorized by Congress, and has said that as he's testified in front of Congress, believe it or not. However, a study analyzed the SEC's rulemaking agenda under his tenure found that 39 rule proposals, or approximately 80%, were not required by congressional statute. Many of the proposals overlap and could have unintended consequences that risk undermining our capital markets. Probably a good example is the proposals to change beneficial ownership and securities-based swaps and their disclosures, and how that may impair liquidity. This could lead to harmful activities, such as front-running or diminish corporate governance checks and balances, I guess you could say. Mr. Stebbins, can you discuss the authority the SEC is relying on for the climate rule and your thoughts on whether they even have this authority in the first place?
They're relying on their general investor protection authority. There's no specific authority for this rule. They clearly have the authority to pass laws related to the environment because they have them already relating to, based on the investor protection authorization, you could regulate environmental risks. We still make that disclosure already. It's already required. So all material environmental risks are already required to be disclosed. The question is, does that authority let you do this law? I I don't think it's going to be held up. I think the Supreme Court of the Eighth Circuit is likely to find it to be a violation of the major questions doctrine, but that's for the court to decide, not for me.
Very good. My time has expired.